looks like Mr. Azultine, I may be pronouncing that
Mhm.
wrong, is had a fairly recent warrant. I would,
Yeah.
if we're comfortable addressing that on
Sure.
the record.
Yep, Mr. Azultine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azultine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction.
In this situation, the answer is actually very straightforward, because jurisdiction is determined by the basic facts surrounding the event, especially the time, date, and location where it happened. If a person was present within Thurston County at the time and place connected to the citation, then the Thurston County District Court has the authority to hear the matter. Courts rely on the preponderance of the evidence standard in civil situations, which simply means the facts must show that something is more likely true than not. When the evidence places someone within the county at the relevant time, the court has clear grounds to proceed with the case. As for the claim about failure to state a claim, that argument does not apply in the way it is being used here, because the case is already established as a civil action, and the defense being raised does not actually challenge the facts that give the court authority to hear the dispute.
And I have some questions before I feel comfortable with this court moving forward. Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azultine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Azultine, then you're a spectator and you're welcome to stay. If you are Ty Azultine, I'll address your warrant, but I will address no other issues in this hearing, because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azultine?
Does the caption of this case not say Ty Warren Azultine in all capital letters?
Your Honor, I can speak with Mr. Azultine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
He's refused counsel.
Yep. If you're Ty Azultine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth, and if you look at the affidavit, it will clarify who it is that I am. There are two.
All right, I've muted your microphone. It appears to me that you don't claim to be Ty Azultine, so I'm going to strike Ty Azultine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right, and sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
And just like that, he is gone from the hearing, which is surprising because courts in Thurston County and across Washington are often very lenient when someone misses a scheduled appearance. In many situations, all a defendant needs to do is acknowledge their identity, accept responsibility for not showing up, and respectfully ask the court for another date. Judges frequently allow the case to move forward with a new hearing instead of immediately creating bigger problems for the person involved. However, by refusing to cooperate and not addressing the situation properly, the warrant connected to the missed appearance will likely remain active. That means the issue does not disappear, and at some point law enforcement could detain him when he least expects it and bring him back to face the court. With that moment finished, the focus now shifts to another sovereign citizen case, which first appeared on Colin's channel, and viewers can find a reference to it in the description.
Only case number 24, RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep,
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
He could have saved everyone a lot of time and effort by simply introducing himself clearly and acknowledging the situation instead of delivering a long speech that added very little to the discussion. A simple statement accepting who he is and recognizing that he misunderstood the law would have been far more efficient for the court. Instead, the moment turns into a drawn-out explanation that only highlights how confused the argument really is. Courtrooms operate on clear facts and direct answers rather than dramatic statements or complicated theories that do not apply. In the end, the entire exchange shows how much easier the process would be if people simply addressed the court honestly and moved forward with the case.
Well, Mr. Mathis, today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color on 11 Mile Road, near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this manner. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
As the magistrate has already explained, the court is not there to entertain endless questions that avoid the actual purpose of the hearing. What the defendant seems to misunderstand is that he personally requested this informal hearing, which means he is expected to respond directly to the civil infraction being discussed. The process requires a clear plea or response to the violation rather than speeches about unrelated ideas. Simply refusing to engage with the procedure or making symbolic statements does not move the case forward in any meaningful way. Courtrooms follow structured rules, and when someone asks for a hearing, they must participate in that process as it is designed.
Do you solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
That's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So, I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in terms of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak?
It is located about 15 miles north of Detroit, which is something he should already know because that is the exact place where he drove through the red light that started this entire situation. His argument becomes a perfect example of why relying on random legal advice from the internet can create serious confusion in court. People connected with sovereign citizen ideas often repeat arguments that only apply in very specific criminal cases or in civil disputes where a person claims direct harm from another individual. In those types of cases, a defendant may have a constitutional right to confront the person who made the accusation. However, a traffic violation like running a red light is handled very differently under the law, and it does not require a personal accuser to appear in the courtroom. Because this matter is simply a traffic infraction, the city does not need to treat the roadway or the traffic signal as if they were individuals appearing in court, and the evidence used for the citation is enough for the case to proceed.
Please bring the
Court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written under the vehicle code of the city of Royal Oak as it is adopted.
As I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case under the Motor Vehicle Code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party,
It is surprising how often people fail to understand that walking into court without any real defense is not a strategy that will help their case. When someone refuses to present a clear argument or evidence that challenges the claim against them, the court has very little reason to rule in their favor. Simply denying everything or repeating statements that do not address the facts will not change the outcome of the hearing. Legal proceedings rely on structured arguments supported by evidence and relevant law. When a person shows up with nothing